I'll send you again schedule.
Thank you.
What about Tatiana?
Tatiana, I think that she would join according to the agreed session.
Yes.
So yeah, I talked to her yesterday, and I think that she's scheduled for tomorrow, as far as I understand.
Yes, her schedule is for tomorrow. You're right, absolutely right. Here, I mean, all our alumni and everybody are across the India, across the country.
Good afternoon, ma'am.
Good afternoon.
Mehak.
Maybe.
I think we can begin with the song of our society now. Huh? Prachi madam, you can give the outline.
Sorry? Is there music on your side or it's in somebody's side?
Hello. Hello. Good afternoon, one and all. First of all, I would like to pay tribute to Dr. Panjabrao Ufak Bhawesab Panjabrao Deshmukh, founder of Sri Shivaji Education Society. I, Dr. Nandakishore Ramteke, Professor, Panjabrao Deshmukh College of Law, Amravati, welcomes to all the participants, delegates, research scholars for attending 2 days multidisciplinary online conference, which is organized by Dr. Panjabrao Deshmukh College of Law, Amravati, in collaboration with Senatorial Solicitors UK. I welcome to all eminent speakers and the guests for all over the country who share their knowledge and vast experience with the student community. I welcome to all delegates who are present in inaugural session in this multidisciplinary international conference. This is the first international conference in the history of our college, which is completely conducted in digital platform in line with social distancing. The theme of this international conference is emerging issues and challenges in human rights, commercial law, women empowerment in contemporary global society. The theme of our topic covers the certain challengeable issues under society, and therefore we are divided conference into 2 parts. The technical session 1 for commercial law, technical session 2 for women empowerment, technical session 3 for human rights. For each technical sessions, 1 international resource person and 1 Indian resource person invited to discuss the above theme. I would like to say that these technical sessions are arranged in line with international standard time. After the inaugural session, the first technical session start immediately. Thereafter, I am already told about that after the inaugural session, all the sessions are compulsorily attended by all the delegates, all the participants. After that, submission of feedback form, which is given to you in the last technical session, that should be filled up and submitted to the our login ID. Now I am called Prachi Kudu Madam to proceed with the inaugural session.
Thank you, sir. Thank you, sir. A very warm welcome to all the delegates on the inaugural function of 2 days multidisciplinary international conference on emerging issues and challenges on human rights, commercial law, women empowerment in contemporary global society, organized by Sri Shivaji Education Society, Amravati's Dr. Panjabrao Deshmukh College of Law in collaboration with Senatorial Solicitors, United Kingdom. Present international conference focuses on the burning and sensational issues of human rights, commercial law, and women empowerment. The international nature of the conference gives platforms to share the latest and innovative ideas with peer and senior group of the people from the different part of the world. Senator Solicitors Managing Director Honorable Sajid Sheikh has given immense support for organizing the conference. Sir would be joining us soon. The multidisciplinary approach of the conference purposes to bring together number of ideas and perspectives of various fields such as commerce, science, management, and others. All the three sessions have their own importance in the age of global development. For this purpose, Technical Session 1 has been planned on the commercial law field, Technical Session 2 on women empowerment, and Technical Session 3 on human rights. Here is a brief outline of the international conference. As we are going to pursue a 2-day international conference, on day 1 we will be having an inauguration function. As the guest, Honorable Advocate Yashomati Thakur, Cabinet Minister of Women and Child Department, Government of Maharashtra, and Guardian Minister of Amravati would be present. Professor Dr. Dilip Uke, Vice Chancellor of Maharashtra Law University, Mumbai would be present. Along with him, Advocate Jayant Dattatreya Jaybhave, Member Bar Council of India, and Dr. Vijay Kumar Chaube, Dean of Law Faculty, Sant Garge Baba Amravati University would be there. Also, Shri Harshavardhan Deshmukh, President of Shri Shivaji Education Society Amravati would be there. Talking about the technical sessions, Technical Session 1 tends to highlight the hurdles and challenges faced in the commercial transactions and commercial law across the globe. To have a clear global vision on this issue, we have international speaker Elena Mangasarian, International Legal Counsel, Legal Tech Specialist from Columbia University, and National Speaker Mr. Vikram Sopti, partner of in-law firm Chandiok from Delhi. Technical Session 2 has been arranged on day 2 of International Conference, that is tomorrow 6th March at Indian Standard Time 1:30 p.m. Session 2 would deal with sensational issue of women empowerment and challenges and hurdles faced therewith. Issue of women empowerment is on flames all over the world and is also sustainable development goal. To have a deep and global insight of women empowerment, we have invited international resource person Tatiana Naviva, co-head of international arbitration at EPM Russia, and Indian resource person Dr. Shashikala Gurpur, Director of Symbiosis Law School, Pune. Technical Session 3 on human rights is also planned on day 2, that is 6th March at 3:30 p.m. Indian Standard Time. To talk on this issue, we have with us International Resource Person Mr. Shajid Sheikh, MD of Senator Solicitors, United Kingdom, and esteemed International Resource Person Mr. James Collins, Barrister from UK, and Advocate Rajendra Anbule, Senior Counsel, Bombay High Court of Bombay Bench. I sincerely wish that conference will be great success, not only as opportunity to share this knowledge and experience, but also to the beginning of a long and strong friendship amongst the fellow educators devoted to most meaningful and worthwhile task of teaching and training our youth who will shape our future. Today we have with us Chief Organizer of today's conference, that is Dr. Varsha Deshmukh, Principal of Dr. Panjabrao Deshmukh College of Law. She has served as ex-principal of Vinayak Vidhi Mahavidyalaya and has worked with many committees and have conducted many guest lectures. She has been coordinator of Human Rights Diploma YCMOU Nashik Center at Amravati and has major research projects sponsored by UGC New Delhi. She has attended and presented research papers in about 60 international, national and state level conferences. She has been awarded National Women Empowerment Award and by International Association of Educators for World Peace, Women's Agency for Generating Employment, Women Bhaskar Award, Best Paper Award at International Conference Kuala Lumpur, and Municipal Corporation Award by Municipal Corporation Amravati for Legal Awareness Educational Programs for Women in the Society. And the list would go on. To welcome is to show honor. To welcome is to establish integrity. My humble request to Honorable Dr. Varsha Deshmukh, Principal Dr. Punjabrao Deshmukh College of Law and organizer of International Conference, an important guiding force for this conference, to deliver the welcome address.
Thank you. Thank you, Prachi. Am I audible? Thank you so much. Am I audible?
Yes, ma'am.
Am I
Yes,
audible?
madam. Yes, yes.
Okay. Thank you. Thank you.
Yes, yes.
Warm greetings. I, Dr. Varsha Deshmukh, Principal, Sri Shivaji Education Societies, Dr. Punjabrao Deshmukh College of Law, India, Maharashtra, and Amravati, heartily welcome you all on this online multidisciplinary international conference. The title of the conference is Emerging Global Issues and Challenges on Commercial Law, Women Empowerment, Human Rights, Contemporary Society. On the 5th March today, I pay my esteemed regards and respect to the great visionary and educationist, the founder father of our society, late Bhau Sahib, that is Dr. Punjabrao Deshmukh, who is the founder father of this esteemed institution. And I'm happy to welcome you all the dignitaries across the globe for this multidisciplinary conference, namely the president of inaugural session and our president of the institution, Sri Shivaji Education Society, Honorable Sri Harshavardhanji Deshmukh, who is constant source of inspiration and support for the very proactive activities in the institution. The inaugurator of today's conference, Honorable Advocate Yashomati Ji Thakur, the Cabinet Minister, Women and Child Welfare Government of State of Maharashtra, Maharashtra government, and she is the proud alumna of our institution. The patron, Honorable Sri Advocate Gajanan Ji Punkar, second patron, Honorable Dilip Ji Ingole, who is also the treasurer of our society. Honorable Sajid Sheikh, who is Managing Director, Sentinel Solicitors, United Kingdom, and who is also proud alumnus of our esteemed institution. The Dean of our faculty and SGBAU, University Amravati, Dr. Vijay Kumar Ji Chaubey, Honorable Vice Chancellor, Professor Dr. Dilip Ji Uke, and who is the Vice Chancellor of National Law University, Mumbai, Advocate Mr. Jayant Jai Bhave sir, who is
कुछ तो प्रॉब्लम
sorry, some okay, and I welcome Mr. Jai Bhave sir, who is member of Bar Council of India and also member of State Law Commission, and he is the person who has started the first computer library in Nasik. And of all, we have with us the dignitaries from the Russia, the resource persons from the Russia, Elena, who is law faculty and International Legal Counsel, and She is working at Legal Tech Specialist, Columbia University, and at present working in Russia. Also, we have Tatiana Navina, who is the co-head of International Arbitration at EPAM, and at present she is working in Russia. So friends, I also welcome the dignitaries of the first technical session, Mr. Vikram Sopti and Dr. who is partner in law firm in Delhi, New Delhi. I also welcome Dr. D.S. Dhote sir, who is the principal of Brijlal Biani Science College here, and the Shaista madam, who is also officiating principal, Naujivan Law College, Nasik, and Dr. Vaidya madam, who is principal, Government Law College, Mumbai. I also welcome Anjali Thakre madam, who is principal, Sri Shivaji Education, Physical Education College, Amravati. I also welcome Mr. James Collins, who is a barrister from UK. I welcome Advocate Rajendra Anbule sir, who is the senior counsel and AOR at Supreme Court, New Delhi. I welcome Dr. Smita Deshmukh madam. I welcome Archana Gadekar madam, and all my team who has really worked hard for this conference. The main chief convener of this conference, Dr. N.K. Ramteke sir, Dr. P.Y. Dabade sir, Professor M.U. Ingole sir, Dr. Manish Wadive, Dr. Prachi Kadu, and the entire I also welcome all my team members, the convener, Dr. N.K. Ramteke sir, Dr. P.Y. Dabade sir, Dr. Manish Wadive sir, Professor M.U. Ingole, Dr. Prachi Kadu, Radhika Deshmukh, entire organizing team, all our PG and UG students, 5-year students, all the delegates who have given the overwhelming response and submitted their research papers to this international conference. Friends, the legal education has changed through the years. The government of India and the Maharashtra have introduced new education policies for bringing out uniformity in legal education at par with national, international level. So this conference is mainly the reason to let us meet new people from various countries for knowing the culture and to meet the eminent personalities through research scholars and the stalwarts in the legal fields. It also nourishes your brain and open yourself and best practices. It gives an opportunity to meet influencers, experts face to face, and team building. So the reason for the conference is very precious. And when we talk about the various topics we have chosen for this conference, like at the first, I would like to talk about the commercial law. Commercial law is of paramount importance for smooth, fair, and profitable conduct of businesses in every sector of commerce and economy, and also known as the business law. Commercial law is considered to be a part of civil law, which includes the matter and issues of both private and a public law. The global juris essentially offers an extensive and exclusive range of legal services for this vital and magnificent field of law. The Global Jurix is a famous, full-fledged legal organization of India and the world immensely reputed for its responsible, rigorous, innovative, and economic legal services to almost all the sectors to the economy in all round and across the world. So, ladies and gentlemen, after the survey, it is fact that the 50% of the world population belongs to women, but still they need to empower, and in true sense, we wanted to know the views of all the delegates present here about the women empowerment. According to me, women's empowerment can be defined to promoting women's sense of self-worth, their ability to determine their own choices, and their right to influence social change to themselves and others. It is closely aligned with the female empowerment and fundamental human rights, although the women empowerment topic is closely related to the human rights, but I think we thought that we have to give the separate sphere to the women empowerment, and which is the integral part of human rights. Of course, very soon we are going to celebrate International Women's Day, and this is one of the part of endeavor of celebration of Women's Day on 8th March. So friends, the other theme of this conference is to issues on human rights, which are the concern of at large, at universe. Human rights are the basic rights and freedom that belongs to all people in the world from birth to death. These rights are based on shared values like dignity, equality, fairness, respect, and independence. These ethics are protected and some human rights are more visible than others. It's much easier for people to relate to rights like the right to vote, right to fair trial, right to court, and all the new rights which are unknown to the some part of the world, and that will be covered by the faculty's resource person from our other international persons. So friends, I'm sure that this brainstorming upcoming technical sessions will definitely give you insight, and it will contribute to the new views and the issues. And I wish all the success to this international conference and wholeheartedly welcome you all again for the 2 days international conference. Thank you. Thank you so much.
Thank you so much, madam. Okay. She overcame everything that was meant to destroy her. She designed her life and wrote her own story. Each time she stood up for her own, unknowingly, she stood for all the women, a true symbol of women empowerment. None other than Honorable Advocate Yashomati Thakur, Cabinet Minister of Women and Child Department and Guardian Minister of Amravati. Madam has consequently 3 times won elections in Maharashtra Legislative Assembly from Tiwsa constituency of Amravati district. IT has bestowed many responsibilities on her shoulders. She has been appointed as AICC Secretary of State of Karnataka and Working President of MPCC, All India National Congress Committee. The list is very long. To cut short, she is working on various central government and state government committees and corporations. She is dashing, courageous lady. More above, has been awarded as Best Shooter at her student life. She is a good debater and good orator, felicited with many awards and accolades, role model for youngsters. We are indeed blessed to have such a dynamic personality as inaugurator of international conference. Honorable Advocate Yashomati Thakur had an urgent meeting deciding women policy and major decisions in Legislative Assembly session. Thus, she could not be present over here with us. But her wishes and blessings are always with us. May I request technical team to play the same.
Namaskar and a big hello to everybody. I am happy to inaugurate today's virtual function and meeting, and I'm happy to know that Sri Shivaji Education Society, Dr. Punjab Rao Deshmukh College of Law, Amravati, in collaboration with the Senatorial Solicitors UK, is organizing a virtual international multidisciplinary conference on emerging issues and challenges on human rights. It's a big issue and a big subject. Commercial law, women empowerment in contemporary global societies. I'm confident that the deliberations at this international conference will be immensely useful and effective for the transforming the society. It will provide a supportive environment in which ideas will be generated through interactive sessions with eminent speakers and leading researchers. I congratulate Principal Dr. Varsha Deshmukh, convener, the co-conveners, the teaching and the non-teaching staff, and students of this August Institute. I wish all of you all a grand success for this international conference and the publications of reviewed research journals of the esteemed institutions. Congratulations once again, and wish you all a wonderful session for the next 2 to 3 days, and thank you for inviting me. Thank you.
Thank you, ma'am. Though madam could not join us due to her busy schedule, and she was busy for upliftment of the women. She was busy in deciding women policy and major decisions in Legislative Assembly session. Though not able to join us, her wishes and blessings have reached us. Thank you. You are really an inspiration for all the women and true symbol of women empowerment. We are proud to have you as our alumni. It is matter of pride for us that today's guest of honor, we have Honorable Professor Dr. Dilip Uke, Vice Chancellor of Maharashtra National Law School, Law University, Mumbai. Before joining Maharashtra Law University, Mumbai, he served as Pro Vice Chancellor and as the Acting Vice Chancellor of SIM University, Nanded, Maharashtra, and Professor and Head of Department at Department of Law, Savitribai Phule Law University, Pune University. In the past, he was appointed as Visiting Research Fellow by New South Wales University, Sydney, Australia, and awarded UGC Fellowship to visit France. As an invited speaker, he has spoken at numerous international conferences. He has been a member of various committees of university, UGC, public service commissions, including Judges Selection Panel. He was conferred the Best Academician Award by Indian National Bar Association, New Delhi. We are blessed to have such a renowned academician with us. You are humbly requested to address the conference, sir. Actually, sir was not feeling well and I would request, sir, if it is possible for him to address us. Due to health reason, sir would not be able to join us. But blessings and wishes of sir are always present with us. We have Honorable Dr. Vijay Kumar Chaube, Dean of Faculty of Humanity, Sant Gadge Baba, Amravati University, with us. As chairperson, as guest of honor today, sir has been ex-member of Management Council of Sant Gadge Baba, Amravati University, ex-member of Board of Studies, Faculty of Law at Amravati and Nagpur University. Much I tell about sir would never be enough. He has been visiting faculty at Maharashtra Judicial Academy, Uthan, Academic Staff College, UGC, and Human Resource Development Center. He has worked on many committees and is member of State Committee for Cyber Laws, member for Administrative Reforms Committee, and Committee for Making Common Statutes under Maharashtra Public Universities Act 2016. He has immense experience of research and has experience of research in instrumental in policy making documents. I would just say Honorable Dr. Vijay Kumar Chaube is treasure house of knowledge. It is my humble request to sir to address the conference. Dr. Vijay Chaube, sir. Okay. Due to technical reason, sir has not been able to join us. As guest of honor, we have very dynamic Advocate Jayan Jai Bhave, who is member of Bar Council of India. He has formed an association of 15 practicing lawyers at Nashik and Mumbai, named Advocate D.T. Jai Bhave and Associates. He has standing practice of 35 years in civil, revenue, land acquisition, criminal, arbitration, consumer, cyber law, conveyancing, matrimonial law, and banking law. He is member of Maharashtra State Law Commission and member of Maharashtra Bar Council, Maharashtra and Goa. He has also authored many books and marked his name in academic field. His achievements are laudable. He started first computer library in India at Nashik in 2005 under auspices of Nashik Bar Association and has also established computer law library throughout the state of Maharashtra and Goa at 425 places. It is my humble request to sir to address today's conference. Sir has joined us.
Hello. I am audible, madam.
Yes, sir, you are audible.
Yes, sir, you are audible.
Thank you very much. Honorable, respectable chairman of the institution, also honorable, respectable advocate Yashomati Thakur, the honorable minister of the state of Maharashtra, respectable principal madam, Srimati Varsha Deshmukh, all other dignitaries who have gathered on this very important topic of a international conference, and all the participants, colleague friends. I, first of all, just apologize that I have to travel immediately for some urgent meeting, and therefore I could not get it connected properly, but still I hope that I am audible and I am able to participate during this travel also. First of all, taking up a challenge of discussing such types of subjects in a law college is really appreciable. As a member of Bar Council of India, which is an apex body of the not only lawyer but the policy deciding body of the legal education, I appreciate this in 25,000 new advocates have been enrolled, and which is a record in a country. Also, you must have observed as a law college that this time, whatever the seats was available for the law education, demand for 4 times. Madam must have faced a lot of problems for an admission. Of course, every process is a computerized process, but still consider this demand, which is a 4-time demand than the available seats of the law legal education. So naturally, the question must arise in the mind of every stakeholder of the judicial system that why such demand has been coming to the legal education and particularly the courses of the law. My own vision, which I want to share, practical vision, because academically we can talk. As far as the academic aspect, the practical aspect is concerned, the corona has given a new dimensions, and now practically now there is a virtual hearing of each and every matters, and therefore there is a scope for every person, right from an Amravati, right from Nagpur, right from any other district place, the lawyer can practice on different forums. They can deal with different commercial institutes, and the another aspect is that the litigation has also taken a new shape. The youngsters should study what is the changing phenomena of this entire litigation. So many tribunals are established. Now you can just observe one particular institution, NCLT. If you see that NCLT, the entire litigation relating to the company and all ancillary aspects of that litigation has gone to the board of an NCLT. See the litigation of the banking. Most of the 90% of the disputes in a banking institution has gone to the DRT. And one by one, in intellectual property rights, the different forums are coming, the different procedures are coming. In a real estate, apart from a consumer, RERA is coming. So it is not only the area of a civil practice or a criminal practice, which was a traditional practice area for a practicing lawyer, which has remained as a scope for the practicing lawyers. So the dimensions are quite different. They are developed in an entire 360 angle, and the young generation who are well acquainted with the entire technology, they have understand this, that this is a different field. And for that purpose, the legal education in an entire country, I will say, not only in the state of Maharashtra, is now on a second position as far as priorities is concerned. First is a medical and another is the legal education. Even an engineering is not having that priority than the legal education. So this aspect makes your topic, particularly topic of the commercial laws and also the topics relating to the human rights are concerned, that it becomes very important. On this angle, these topics which are propagating in this particular seminar are really appreciable. As far as the commercial laws are concerned, it is not a general topic, and you will have to dealt it in a different angle. See a simple new act, a commercial suits act, a simple one act. It has given a different dimensions in a civil litigation itself. And in a summarily manner, a huge quantums of the disputes will be brought before the commercial courts. So what is the procedure of the commercial courts? What is the jurisprudence of that particular commercial court? Which types of an adjudication will be permissible? Which types of a defense will be available in a commercial courts? So while discussing this, apart from a theoretical aspects and a principle, it will be my humble request to the organizers that one should focus on these particular aspects. A particular act should be taken, and that act should be focused. Commercial Suits Act, the NCLT, the DRT, and by focusing on this particular act, the magnitude of the commercial law and the commercial litigation, which has uh, given a new dimensions to the younger generation of the advocates and the entire legal fraternity, they will have a complete different outlook towards this particular aspects of the commercial law. As far as the law relating to the women are concerned, the social legislation and with the development of the Domestic Violence Act, it is coming in a different shape before the society. Unfortunately, development of the society also gives certain different, you can say, side effects. In an IT sectors now, there is a report that 40% the husband and wife who are working in an IT sectors, they have to face the divorce litigations. The matrimonial disputes therefore has become a different type of a litigation. It is not only remaining a dispute of a matrimonial nature, it is also a dispute relating to the commercial disputes. This particular aspects has been dealt by Bombay High Court. You can see the judgments of Honorable Justice Abhay Oak. In the judgment, now it has been specifically warned that the lawyer who is dealing with the matrimonial disputes, he is not only dealing with the relationship, but he is dealing with various types of commercial dispute which are incorporated in that matrimonial disputes also. This particular aspect of a matrimonial dispute should be discussed in this seminar. And the judgments which Bombay High Court different vision for dealing with a matrimonial dispute will have to be considered. I hope that these all aspects will be dealt in detail. I promise that whenever possible, I will personally visit your institutions and will like to be a part and parcel of your entire activity. And in that State Bar Council Goa, express my all best wishes for the success of the seminar. I hope that the participants will get something new vision by from the speakers are very eminent. I have seen the list of the speakers, and from their entire discussions, we will get an entire new vision for the development of these very important topics of the law. I am thankful for giving me this opportunity, and I promise that next time.
Thank you so much, sir. We are very thankful for the efforts of Honorable Jayant Jai Bhave, sir. Though traveling, he joined the conference and enriched us with fine practicing and lawyering skills. Sir's advice is very prestigious and would boost the young advocates to develop a new outlook. Your presence has added glories to the conference. Advocate Yashomati Thakur, Honorable Yashomati Thakur, was not able to join us earlier, but in spite of her busy schedule, she has joined us. I request Madam, Yashomati Madam, if she would address the conference.
I think Chaube sir has joined. Madam is very much here, but she is busy in one meeting.
Okay. We
But she
understand
can't speak in
priorities
detail.
of Madam. She is busy in empowering Indian women and women all over the country. I request Dr. Vijay Chaubey sir to address the meeting. Earlier, sir could not join due to some technical reason. Laurels may add to one's fame, but in special cases, we add the thirst to explore and contribute more towards society. In this challenging world, one such eminent personality and key person behind the decisions taken in Sri Shivaji Education Society is Sri Harshvardhanji Deshmukh, President of Sri Shivaji Education Society, Amravati. Sir has received his law degree. He was State Minister for Revenue and Tourism, Maharashtra government. Also, he has looked after portfolio of agriculture, horticulture, water conservation, Minister of Maharashtra. During his tenure as minister, many policy decisions were taken by him and many thematic reforms were also brought by him. His contribution in cooperative sector is noteworthy. Now, Sri Shivaji Education Society is progressing by leaps and bounds under his leadership. Due to unavoidable circumstances, Sir could not join us. Dr. Vijay Kumar Chaubey Sir has just joined us. I request Sir to address the conference.
This is really the very good conference that we with regard to this very burning issue, rather on human right, comprising so many other issues regarding, we can say, human right and women empowerment and commercial law and all those. This particular topic that has been chosen by Dr. Panjabrao Deshmukh College of Law for the international conference is really, we can say that it is rather the very burning issue. And on this particular issue, as we are witnessing at present, the war is going on at international level and so many things are at stake. And the problem that is coming out of that is really prove that this particular issue is very much incidental and required to be deliberated on such a platform, because we had, after Second World War, had never been witnessed such a complexity with regard to the human right and other issues, women empowerment. We can see that Russia and Ukraine are at war and likely to be expand in other part of the world. Therefore, whatever is the requirement of the human right that justify that the fair society and the society that is based on certain values of human right, respect of human right, and whatever the outcome of Second World War with regard to this emergence of the human right as a parameter to justify the action of the state is really now we need to give the second thought for that particular things and need to deliberate on this particular point at a global level as well as at each and every level where we can just find an opportunity to discuss. The human right is really, we can say that it is really the issue that will require to be considered as a best parameter to determine that whether and how this particular other institution can act upon, and the power that a sovereign is enjoying without any justification, without any rational, and just putting entire world, entire community, entire civilization into the war is really to be tested on the parameter of the human right and whether they are legitimate in doing so is the main concern in present days. In addition to that, we can just see that at present there are so many such things are there in a developed country or developing countries. They are facing a lot of problem right now and we are just going into that particular direction. War definitely is not restricted to the country, but it is also having some post-war impact. And in day to come, we will just see that this particular things will become more worse, and the entire humanity has to now give the thought that whether such particular things are suits to our present scenario, because this particular word, as most of the time has been said, that this particular word is the only one piece of things that we are having in our hand, and if we cannot preserve it, definitely in day to come it will going to hamper the entire humanities, and entire things will going to collapse. Therefore, in this particular things, it is required that we must deliberate such a very important issues of human right from such perspectives which is going on in the entire part of the world. So far as we can say that women empowerment is concerned, or commercial aspects are there, global aspects are there, considering each and every level, this particular things now require several things to be deliberated. The participants there definitely has come up with their points to be get discussed with regard to this. But more important is that what I will request that all participants and those who are participating as a participant or paper presenter must emphasize that how they are going to give the way out for this solution to this problem that we are facing. And I will just tell you, this is not the only thing that we are just discussing from the traditional point of view we are need to discuss, but I think that we need to discuss all this scenario from the war that is going on, because this war is having the very long lasting effect on each of one. Suppose, for example, if the price of the commodities was raised, then definitely those people, even the student, even the child, even the teacher, every one of us is going to get affected by one or the other way. If suppose, for example, the price will hike, or suppose for example, it is beyond the reach of the common people, then again we need to understand that in what way we are going to respond to the current scenario. Therefore, this particular after 24th of February, the world is moving on some very different direction, where the questions of supremacy among the supreme power is definitely in competition with or contradicting with each other. But at the same time, the impact is on the entire people. It has been reported that more than around 20 lakh, 30 lakhs people has been already displaced out of this war. Even India, those particular talented students who had been to the Ukraine has now been come up without any future to that particular group who has been left now Ukraine, and they are in the advanced stage of their education. Similarly, those other in that particular vicinity, they have also coming back and creating the problem. At present, so many people are displaced from Ukraine, and they will be definitely going to migrate to other part of the world, and additionally creating so many problems. Their suffering will be definitely we cannot imagine. Imagine that most of the gents has remained back, and the ladies and old people has been transported themselves to other country. In this scenario, what is going to happen and what way we are going to respond, and in what way the human right will be get violated, what they will do, they are just carrying one simple bags without any future in the different unknown part of the world. These particular things are really such a we can say it is a nightmare for the entire humanity. The war had been taken place, no doubt about it, but here directly the superpower has been involved. We have to understand that now the issues what we are going to deliberating today, or discussing or negotiating on this platform need to be discussed from that point of view, because now the entire scenario at global level is going to change. There is a polarization amongst the power. There is a difference. There is a there is a they are just coming in front of each other in war and conflict with each other. This particular things is required to be addressed through this, because this type of deliberation, this type of discussion may have an opportunity to us to generate the literature and at least to discuss and give the voices to your thought to your expression at an international level, so that we can just think that this particular humanity can be saved from such draconian steps taken by all those power considering themselves sovereign and no under any obligations and not as subordinate to anybody. But entire things at international level is required to be dealt in a proper manner. Otherwise, in day to come, we need to, or I will not say we will say that the entire humanity is need to pay the price for that, and definitely it would be very toughest time to face. If suppose simply considering that the poverty level, or suppose for example commodity rate, or suppose social impact of that particular things is going to have the adverse effect on your income, on your living standard, on the way that resources, how you can manage, all those things are correlated with each other. So this particular things is required to be deliberate in present context. By media news, one can just imagine that this particular contemporary period is really a very shocking phase for the entire civilization. What we had witnessed, probably none of us had been in during Second or First World War. But at that time, the issue was that the destructive capacity of the nation was not much more. But now these world power are having the incremental, or we can say advanced stage of their destructive power, and they are destroying the entire nation. They are just making them spoil altogether. And then whatever the equations that is going on across the world is definitely affecting not to those superpower. They may satisfy their ego, but ultimately it is going to affect all people who are directly or indirectly connected with that particular piece. So I will just really congratulate to the organizer of this particular international seminar for choosing such a very relevant, rather contemporary, or we can say that the such topic, which is really, sorry, having the good outcome and significant impact on the topic, which is really very live one, and the Dr. Punjabrao Deshmukh College of Law, under the new leadership of Dr. Varsha Deshmukh Madam, is marching to take up new topics. And definitely, if the student community, academician, lawyers, judges, and all those are having a chance to discuss on this particular time, and at least have an opportunity to develop their thought pattern, so that they can, by their own point of standing, they can contribute and influence the policymaker. Such type of discussion must be keep on vibrating one, and accelerating the decision-making capacity of the policymakers, so that they can think over this particular things, because we cannot remain silent. We are not merely a mute spectator. We are not merely the, we can say that audience. We are the active human right activists who are having the right to discuss about all these particular things at this particular platform. Those parties who are witnessing this particular things, I will request them that take an opportunity to open your mind, have the sharing of the thought, and particularly discuss those very vital issues, particularly in this age of war. Because otherwise, in traditional manner, definitely we used to discuss about the established political system against which the atrocity has been committed against the human right. Those points are definitely there, but in new, this particular last 10 days has shake up the entire things, and we are now in such a place that we don't know what future or what we deserve into the future, particularly because none of the country will remain, none of the person will be get unaffected, and if this world war or this will get enlarge its circumference and take the other community, other group, other countries, Union or if it will be more drastic, destructive in nature, and in that case, I don't believe that. As far as law is concerned, we are aware that definitely this particular law and order situation definitely help us to control entire things. We see that at world level, at global level, the law and order situation is totally collapsed. at the mercy of those who are powerful. And definitely, the particular things is really such a things that we are witnessing. And now, whatever the things, this I can just guess that the Second World War was made up with the very good event of emergence of the United Nations, which has been established on 5th of October 1945, where those who are winning counterparts come together to join their hand, and then in 1948 they come up with some Universal Declaration of Human Rights. All these things are at the war they have discussed that this particular thing was there, which can check the legitimate action of this group. Now the time again have where we can just discuss what is the good and what is bad, what should be the parameter to judge the issue, in what manner this entire civilization can put and able to put the pressure on those who are taking one-sided decision without considering the suffering of those who are non-directly, they are not involved into the decision making, but they are living their peaceful life. So with this, I will just once again in this inaugural session congratulate the entire team of Dr. Panjabrao Deshmukh College of Law, including Varsha Deshmukh Madam, because she has in the second in the row. I think that she is taking this very good platform, creating very good platform where the person can have the voice to their thought, and really a very good opportunity every one of you have. And I think that if more and more people will join, more and more people is coming to present their paper, they will have the different dimensions on this important topic. I think that this would be the great literature, and ultimately it will get reflected into the thought pattern of those particular who are seriously attending this international seminar. With these, I just once again say that Dr. P.D.C.L, march ahead. You are really doing well. And definitely, if compilation or if the compendium of this all proceeding would have been bind and put together for as a literature for the person day to come who are not having an opportunity to join today, this would be the great help for those who would have an opportunity to go through that what has been done today. So thank you very much in the team, and very good. I think that this day you have chosen very good day, and thank you very much for entire effort you have taken.
Thank you very much, sir. Sir has very aptly marked that under leadership of Dr. Varsha Deshmukh, our college is progressing with leaps and bounds. And also about the conference, the participants would surely try to give recommendations to solve this global issue highlighted in the conference. Now, may I request Dr. Nandakishore Ramteke, convener of International Conference, to present vote of thanks.
Thank you, madam.
Welcome, sir.
I feel honored and proud to have opportunity to present the vote of thanks of this inaugural session. First of all, we are proud to announce that in our conference, total 53 research papers received from the academician and research scholars for the peer review journal. This is the tremendous response which is given by the academician and the research scholars. And this is an unforgettable memories in the history of our college. And therefore, first of all, I would like to thank all those academicians and research scholars on this occasion. Thereafter, I would like to express my sincere thanks to inaugurator, Honorable Advocate Ashwati Thakur Madam, Cabinet Minister, Women and Child Welfare Department, Government of Maharashtra, and Guardian Minister of Amravati, for giving a valuable time and pressing a video and given a congratulation on this occasion. Thereafter, I would like to express my sincere thanks to our guest of honor, Advocate Jayant Jaybhave, members of Bar Council of India, who sharing their views on the topic of international conference. Thereafter, I would like to thank Dr. Vijay Kumar Chaubey sir, Dean and faculties of Humanities, Santa Gadge Baba Amravati University, who gives a valuable guidance on the occasions of this international conference. A special thanks to our chief patron and presidents of inaugural session, Honorable Harshavardhanji Deshmukh, President Sri Shivaji Education Society. Without his motivation and support, we cannot conduct that program. And therefore, on the behalf of Dr. Panjabrao Deshmukh College of Law, we are thanks to all, on this occasion and giving the wishes on this occasion. Thereafter, I would like to special thanks to the co-organizer of our inaugural international conference, Mr. Sajid Sheikh, Managing Director of Sentinel Solicitor UK, for giving constant support for organizing this program. Thereafter, I would like to thank our principal and organizer of this international conference, Dr. Varsha Deshmukh Madam, who constantly inspiring to conduct this international conference. Thereafter, my deep sense and gratitude to the all participants, delegates who are in foreign countries and our countries, and our research scholars who attend this conference and attend this inaugural session and make the event successful. Thereafter, I would like to thank our organizing team, my teachers, my non-teaching staff, who give a constant support to successful this inaugural event. Last but not the least, I would like to thank our technical team, without which this online international conference, it's not possible. And therefore, I would like to thank all those who are present and all those who are help to conducting this program. Thanks once again, and thanks to all. Over to you, Prachi Madam.
Thank you, sir. Laurels may add to one's fame, but in some special cases, we add the thirst to explore and contribute more towards society. In this challenging world, one such eminent personality and key person behind the decisions taken in Shivaji Education Society is Shri Harshvardhanji Deshmukh, President of Shri Shivaji Education Society, Amravati, which is very prestigious and second largest education society in Amravati. Sir has received his law degree and has acted as State Minister for Revenue, Tourism and Irrigation Department, Horticulture, Water Conservation, Minister of Maharashtra. During his tenure, many policy decisions were taken by him and many thematic reforms were also brought by him. His contribution in cooperative sector is noteworthy. Now, Shri Shivaji Education Society is progressing by leaps and bounds under his leadership. Due to his busy schedule, he could not join us together. I request technical team to play his message for us.
It is a matter of utmost pride for everyone associated with the Sri Shivaji Education Society, Amravati. Amravati is Dr. Panjabrao Deshmukh College of Law, Amravati, that the college is organizing virtual international multidisciplinary conference on emerging issues and challenges on human rights, commercial law, women's empowerment and in competitive global society from 5th March to 6th March 2022, that is Saturday and Sunday, and also the college is publishing a peer-reviewed research journal. Great institutions are not built overnight. The pioneering vision of Shikshan Maharshi Dr. Panjabrao Deshmukh translated into reality by incessant efforts of administrators, principals, teaching and non-teaching staff. The college contributed immensely by illuminating young minds and produced lawyers of substance who have played a crucial role in taking the nation forward. Organizing multidisciplinary international conference is a landmark in the odyssey of educational institution. Wishing more honor in the years to come to an institution par excellence, that is symbol of highest standard in teaching and research. I convey my heartiest congratulations to the principal, Dr. Varsha Deshmukh, convener, Dr. co-conveners, teaching, non-teaching staff of the college, and wish that the future brings even greater glory and achievement for this esteemed institution.
We had a very valuable guidance from our President Sir, and his wishes and blessings are always with us. Here, I declare inaugural session to be over. We will soon join for technical session 1. I request audience not to leave the Zoom link.
Good afternoon, everyone. This is CA Anupama Ladda. I am taking over from Prachi ma'am for our first technical session for commercial law. I hope everybody is all charged up, have had their snacks, and all geared up for the technical session. I thank Varsha ma'am and the whole P.D.C.L team for giving me this opportunity and to be able to take you through the first technical session on commercial law. Foremost, I welcome Alina ma'am from our international resource person, who is an international legal counsel, legal tech specialist from Columbia University LLM. And I also welcome Mr. Vikram Sopti sir, partner in law firm Chodiok and Mahajan, New Delhi. The chairman of the session, I welcome Dr. D.S. Dote sir, Principal Brijlal Vianney Science College, Amravati, and co-chairman Dr. Sahista Inamdar, officiating principal, Navjeevan Law College, Nasik. Welcome all of you, all the dignitaries. I request all of you to please switch on your cameras so that we can look at your beautiful faces. Yes, Sahita ma'am, we can see you. Others also, if you could switch on your cameras, it would be a pleasure to have a look at you. Yes, moving on to introduction of our first speaker, Miss Elena Mangasarian. I hope I'm pronouncing that right, Miss Elena. She is an international legal counsel and legal tech expert with the extensive international legal experience. She focuses her practice on international corporate, commercial, business law, and intellectual property. Her background includes advising clients on various corporate and commercial matters, conducting due diligence and researching on the issues of law pertaining to corporate matters and intellectual property, computer law, IT regulations. She is familiar with company law and intellectual property law of the US as well as European community. Elena has considerable experience advising on matters involving the telecommunications and technology industries, particularly international technology transfer. Ms. Elena graduated from Moscow State University, Faculty of Law in 97 and University of Leiden, Faculty of Law in 98, and Columbia University School of Law, LLM, she has done in 2002. A native speaker of Russian, Elena is fluent with English and have working command of French. Welcome, Ms. Elena. Welcome welcome to India and welcome to Amravati. I hope you will take us through the session, and over to you, Ms. Elena.
Thank you very much for inviting for the conference. I'm very pleased to be here and would be very glad to share my experience regarding the current trends and regulations concerning cryptocurrencies and digital assets in the key jurisdictions. I'm very pleased with your kind attention and time, and would be glad to share some piece of presentation when my turn is coming. So, and from this perspective, I'm very grateful and very delighted with your time.
It's your turn. Elena, it's your turn now.
All right. So if I can share my presentation deck. All right. So just a second, please. So can I kindly ask to give me the screen demonstration, screen sharing option, so I could share my. Yes.
Please make her the co-host or allow her screen sharing.
Okay.
You are co-host, you can share now.
Okay, thank you. I'm trying to. Just a second. Okay. For whatever reason, its file, it's not uploading. Just a second, please. Do you see my screen now?
No, not yet.
Not yet.
Okay, let me check because I'm trying to put it on, but for whatever reason, it's not showing. Here we are. Do you see it now?
Yes, yes.
All right. So yeah, great. So sorry about that. All right. So when it's coming to the issues of legal check and in particular regulations of cryptocurrency and blockchain technology worldwide, there are several approaches have been developed since this particular digital assets and technology activity have been created. And of course, there are many different issues and many controversial approaches have been developed since cryptocurrency appeared on the
session.
I'm sorry. So, okay. So, and from this perspective, I could highlight the key areas, key approaches that have been followed by key jurisdictions like UK, European Union, United States. And from this perspective, I hope that brief overview of the comparative approach to the regulatory framework of cryptocurrency regulations in these countries would help you to get better picture of what's going on now and where these trends will go further. So as you know, as far as we are all lawyers and also we perform policymaking activity, the key question for regulators with regards to the cryptocurrency regulations and blockchain technology was how to determine the legal definitions of this particular digital financial asset and respective technology on which it is based and through which it is being operated. And actually, I can cite one industry commentator who recently quipped that imposing harsh regulatory rules on blockchain at this point would be like regulating Alexander Graham Bell's first telephone back in 1870s. And taking into account the rapid development of the blockchain and cryptocurrency in different jurisdictions, the regulators facing quite many, and regulators and legislators are facing quite serious challenges concerning precise absence of the hard, precise, fast, legal and regulatory framework And also there are many concerns how to control the relationship between all participants of the process, like concerning cryptocurrency turnover, blockchain technology operating, and all consequent legal and regulatory issues like taxation, financial control, anti-money laundering issues, etc., etc. If you follow the key areas, I could tell the following conclusions: that there is currently the countries facing lack of common approach and standards and towards regulations of blockchain and respectively to the cryptocurrency regulations. If we take UK approach as a hallmark, at this point, and it's still in place, even though use of blockchain, if we talk about the technology precise, which is more concerning issue rather than cryptocurrency regulations, so it's not currently specified regulated activity under the Financial Services and Markets Act of 2000. Because this particular statute provides definition for regulated activity and respective executive order of 2001. And therefore, UK regulators are trying to apply the definitions and regulatory framework provided by this particular act, FCMA, towards blockchain operation, cryptocurrency regulations, and all related fintech activity. And in general, as for now, any use of blockchain should be examined by regulators on case-by-case basis. And in this case, the regulators can try to determine whether or not this particular activity falls within the existing regulated activity legal definition. So, such example, like if the blockchain is used for operating and multilateral trading activity, or this technology is used for conducting regular payment services. So, and from this perspective, if we talk about the position of the regulator, which is the the FCA, financial conduct activity, appears to be adopted and follow, and it's still in place, wait and see approach, and it's currently I can say that it's somehow limiting itself to discuss blockchain with regulators in other jurisdictions. So UK jurisdiction in terms of approach follows kind of watching and monitoring the process and considering all issues of use blockchain technology and cryptocurrency turnover on case-by-case basis, and this practice still exists. On the contrary, just another example, I can describe Irish approach. So unlike the UK, the Central Bank of Ireland has not formally commented on the approach that it would like to follow with respect to blockchain, and in connection with its application in financial services, and also if this technology is adapted for other users. Therefore, following this kind of neutral approach of the Central Bank of Ireland, the Law Society of Ireland also has not speaked out its official position regarding blockchain, smart contract, and cryptocurrency so far. However, the most advanced approach was used by the Irish government's International Financial Service Strategy of 2020, which places a very significant emphasis on fintech in general and on development of blockchain and cryptocurrency in Ireland. And even though there was a kind of white paper indicating that Ireland would like to develop itself as a jurisdiction which is very welcome for global fintech and cryptocurrency development. So it's kind of very positive approach and very encouraging approach which is being adopted in Ireland for now, and we'll see how it would develop further. If we talk about European Union, so it's also there is also no uniform approach between the members of the EU towards regulations of the blockchain and cryptocurrency. There are no strict rules unless some specific directives that are mostly addressed to apply for digital assets activity and privacy in this area, and as well as compliance with anti-money laundering regulations. Other than that, each use of blockchain is definitely being monitored by various European regulators, starting from the financial service perspective. And back in 2016, for example, the European Commission commented that it would adopt the approach like to see and monitor and understand all types of virtual currency like Bitcoin as well as blockchain, and they didn't express clear position, clear intention towards direct regulation of the digital assets and virtual currencies and blockchain technology. So far, the European Commission and other regulators is taking quite cautious attitude that, and they would like to understand how all this ecosystem is working, what could be the consequences, and how the new laws should be developed beyond the standard requirements of anti-money laundering that are currently applicable when the blockchain technology is being used in virtual currencies. And following this European Commission view, the European Central Bank from time to time produce consultative report that indicates current status of monitoring of regulations of the cryptocurrency and blockchain technology. And from this perspective, also one interesting issue that in Europe, there have been established so-named regulatory sandboxes where all participants of the process, including representatives of regulators, financial institutions, banks, various commercial organizations, public policy analytics, they try to understand how the technology work, how what kind of legal issues can be or already have been raised, and what could be the best way towards regulation of this particular direction. If we talk about the US approach, there is a quite controversial, and again, there is no universal and clearly established regulatory framework so far. And also it was very from state to state. And of course, at the federal level, taking into account that the crypto stock exchanges have been established, like Coinbase, and currently started to operate. At the federal level, they're trying to encourage this activity. But at the level of the states, depending on the particular interest, the legislatures still review what kind of approach should be used and what kind of new legislation has to be implemented in course with the federal approach. It's still under the question. It's still in process. But in terms of the practical examples, how the blockchain as a decentralized technology started to be used for various type of transactions, I can provide the following examples. That since 2017, at least 8 US states have been working on the bills that provide for accepting or promoting the use of Bitcoin and blockchain technology. For example, if we talk about the Delaware Corporation, so there was a bill that proposed switch the corporate registry to blockchain. So, and there are some part have already been implemented. If we talk about, for example, the smart contracts, smart contracts have been assigned the legal value and legal force in Arizona. So, and in certain case law, blockchain has become technology, and the smart contracts that have been executed on the basis of the blockchain have been allowed in the court as an evidence. If we talk about Chicago, so in Chicago, the real estate records have been allowed to be placed and maintained on blockchain technology. So these are, as you see, there are some examples that demonstrate how the technology can be used in practice. But at the same time, as I said before, there is still no uniform regulatory and legislative approach towards this particular activity because of its highly technological matter. There are lawyers trying to adapt the currently existing regulations and laws towards this particular area. However, as far as I understand the matter, the efforts of lawyers can be quite difficult to achieve the task to establish very good legal framework for blockchain and cryptocurrency regulations without heavy involvement of IT technology specialists who are working on blockchain and who are dealing with, for example, various digital assets. So it's quite just once again, I think that the UK, as far as the UK law is mostly hallmark practice. Again, I would like just to highlight that when it comes to the regulated activity, the key threshold questions that was raised before the UK regulators was whether the use of the blockchain can constitute a regulating activity within the scope of the FCMA Act of 2000. And consequently, each case of such activity should require specific permission from the regulator, from the FCA of the the Prudential Regulator Authority for the particular firm or company to carry this activity out. And this particular issue is being reflected in Section 19 of the FCMA Act of 2000. And again, at present, there is still no specific regulated activity definitions that cover blockchain. However, the particular use and features of any application of blockchain will have to be examined and monitored, as I said before, on a case-by-case basis in order to determine whether it falls within an existing regulated activity and whether or not the respective permission is required. So it's just a practical example how the current provisions of the FCMA are applying to the blockchain activity. A couple of more issues concerning specifics of the blockchain regulations in the US. And I would like from my side to share with you some good analysis that was given in particular in the Columbia Science and Technology Law Review. And it provides very good analytics concerning blockchain regulations in the US. And again, according to the recent review, at the federal level, the government still has not exercised any constitutional preemptive power with respect to regulations of the blockchain and respective exclusion of the states. And but usually this practice is applicable with ordinary financial regulations. And so the states at this moment have a full discretion to introduce and develop their own rules and regulations. And in my previous example, they precisely demonstrate this this practice. And Also, another example that I can highlight, even though the New York State still didn't enact statewide legislation recognizing blockchain for record-keeping purposes, nevertheless, back in 2015, it became the first state in the United States to regulate virtual currency companies through the state agency rulemaking. So it's another example how individual states demonstrate the approach towards regulations of the blockchain and companies that operate with virtual currencies and digital assets. So some other examples that I already highlighted with respect to, for example, Bitcoin, we know the most advanced example was establishment of the Coinbase and as an official cryptocurrency exchange. And at this moment, also the development takes place at the US Commodity Futures Trading Commission that has used a specific blockchain technology, a cryptocurrency trading platform, and it provides approval to become the first federally regulated digital currency option exchange and clearinghouse in the US. It's also kind of good example of how the regulators work in the US and which approach they will use. As a summary, as far as we all understand that blockchain technology is quite specific ecosystem, and cryptocurrency is becoming very interesting tool and instrument of the financial resources. And from this perspective, there are plenty of legal and regulatory issues that have to be resolved, monitored, and somehow implemented. And one of the main challenges that are being raised by regulators in almost all countries, that for any new technology, in order to become widely adopted, the users have to understand its legal status, its modus operandi from the point of view of specific legislation. And as far as the technology, blockchain technology is specifically designed to facilitate the transactions of value, the users of such technology will need to know how the technology intersects with each of the following legal matters. First of all, it's a regulatory regime that is applicable to use the technology, specifically in the financial service context where the blockchain is mostly widely used. Regulatory issues relating to data protection and anti-money laundering have to be directly applied and adjusted towards use and operating of the blockchain technology and cryptocurrency assets. The next problem is determination of the specific contractual relations between users and particular allocation of the rights and obligations of the parties, and specific issues of transfer of titles to the specific assets or property rights to the of the value. Also, it's very difficult currently to review and monitor the consequences and what should be done in case of any failure of the technology, of the blockchain technology, or elements and software which is used in order to make it operative. Cybersecurity issues becoming on the top priority for regulators, for participants, and for companies who are operating with blockchain and use virtual currency. It's very unclear in many jurisdictions how to mitigate or exclude or assess the insolvency risk of the participants, because again, the legal status of technology and the virtual assets is still quite vague. And that's how I see the main problems that are being faced by key jurisdictions that have been demonstrated in previous review. And I hope that some of these issues would be interesting to analyze, monitor, and work with this towards the successful and effective resolving. And this international experience can be positively used in your country and in your activity. From this perspective, I think my introductory speech is over, and I would be happy to follow your questions, and very pleased with your attention and time. Thank you very much.
Thank you, Alina. I request the participants, if anybody would like to ask any questions. Yes, I think we do not have many questions. Thank you so much, Alina. It was wonderful listening to you, and thank you for accepting our invitation. And
thanks a lot.
Thank you. Thank you so much, and being with us. Thank you.
Thank you. Have a nice day. Thank you.
Yes, moving on to our next speaker. I would like to introduce Mr. Vikram Sopti. Vikram sir specializes in dispute resolution and competition law. He brings a wealth of experience from working with a broad range of clients. He has acumen for strategizing complex legal disputes and regularly advises on litigation matters before the Supreme Court. Sir has extensive experience in domestic and international commercial arbitrations, advising clients in engineering and construction sectors, telecommunication, commercial contracts, banking and finance. His result-oriented strategies and commercial prudence, which maximize value and minimize costs, make him an instant winner with clients. Vikram sir has recognized as a rising star in 2019 by Legal Era magazine, and for his vision, leadership, innovation, and accomplishment. He's also heavily involved in a wide range of competition law matters. He provides insightful and well thought out advisory support, specifically in relation to cartels, unilateral conduct, vertical restraints, complex merger transactions, and joint ventures. Sir provides strategic advisory service that helps clients navigate through the complex legal maze of extant regulatory and policy framework in India. We welcome you, Vikram sir, and we are happy that you have accepted our invitation and joined us today morning, for with your valuable guidance on this subject. Over to you, Vikram sir.
Thank you so much. Thank you so much, everyone. I would like to thank Dr. Deshmukh, who has given me this opportunity of coming here and speaking on certain interesting topics. There are very relevant topics which have been chosen today for this seminar, human rights being one of them, women rights, in fact, being one of them. Commercial law is something that I'll be dealing with today. And a very important facet of commercial law that I'll be dealing today with is competition law. We heard previously also that competition law is not just one generic term, but it applies in various spheres. The Commercial Courts Act, it can be fought in DRTs, it has been fought in NCLAT, where companies fight out with each other, and the practices of the companies are questioned in all these laws laid down. I am dealing with a particular law in this extent, which is the competition law. If I may be allowed to have access to the screen share so that I can also share my presentation.
Technical team, please do the needful.
Thank you. I hope everyone can see the screen now.
Yes, we can.
Okay, sir. Thank you. So for all of you listening, I know competition law is a relatively new law. This law, even though the act is Competition Act of 2002, this came into being partially in May 2009, and the rest of the part came into was enforced on in March 2011. This law is important for us as a general public and also for companies otherwise. By way of examples, I can actually tell you this, which would make it much clearer. Let's say today, all the cement manufacturers decide today that the price of cement will be increased by 100 rupees. all of them decided together. All of them decide that nobody is going to disagree with this arrangement. So all of them will be charging 100 rupees extra from tomorrow onwards. Now, this in typical terms is called an anti-competitive agreement, or in common parlance, we also call it a cartel. This is something that the Act prohibits or treats it illegal. Another example which the Acts deal with is an abuse of dominant position. We all have seen examples of these, although we don't particularly categorize them as an abusive behavior. I don't know whether you guys remember it or not, but I surely do remember when Microsoft came into the picture, when computers were the thing, smartphones was not there. Microsoft was the king of computers. Their operating system Windows was actually used by all. So at that time, Microsoft tried to leverage its position, its strong position in the market, by putting a condition on all the computer makers that if you want to use our operating system, that is Windows, you would have to give us, first of all, royalty. Plus, you would also have to ensure in their agreement it was given that you cannot tailor our operating system to allow anyone else access to our browsing software. So what it means is when we opened the laptop, we had as a default the Internet Explorer at that time as the browser. And Netscape, which was a competitor of Internet Explorer, suffered massively because of this strategy or because of this business tactic of Microsoft. This was turned by the European Commission during that time. This was in 1990s, late 1990s, as an abuse of dominant position by Microsoft. So these are a few examples that the Act tries to tackle with these kind of conducts. As we've discussed, starting this being part of the commercial law, it is an economic legislation. So there are certain objectives which it tries to achieve. And as I said, it prevents practices which may cause an appreciable adverse effect on competition. This term is widely used in the Act, which is in short form called AAEC, appreciable adverse effect on competition. So I should have the activities of these undertakings or these enterprises should have a maximum impact. And when can they have a maximum impact? When they actually command a lot of market power. Like in my example of the cement manufacturers coming together and deciding to increase prices. Now, if you take that example and then just change the players to, rather than being the manufacturers or cement manufacturers, let's say 2 players in a particular area decide to cartel and fix prices, that may not have an appreciable adverse effect on competition. So that may be used as a defense by those 2 players that even if we are cartelizing, even if we are entering into these agreements, these do not have an effect on competition in the market. Because let's say those 2 players will say there are many players from which the general public or the builders or the relevant parties who want to buy cement can still go ahead and procure cement from, and they would still be serving at a lesser price. The other objectives that the Act tries to achieve is to promote and sustain competition in the market, as I said. It is also in the interest of consumers, as we can all see, because it allows us variety. We don't get stuck by the same good again and again. We are protected from the abusive conduct of dominant enterprises. We are protected from the collusive conduct of manufacturers or producers or sellers who try to collude and then fix prices or limit production. A very important example of cartel is OPEC, Organization for Petroleum
Screen hasn't changed. Screen hasn't changed.
Yes,
Sorry
yes,
to disturb.
yes. No worries. I'm just giving a background here. So I will deal with the slides later on. So OPEC is also a very important example where, as we all know, all the exporting oil companies or the manufacturers of oil in the world, the major part, I think they control over 80% of the reserves in the world. They have decided upon the prices, which affects the market. We see this with the current war, the Russian stand, and how it's impacting the oil prices. But that's an exporting. So the Act provides an exemption because anything which is happening exporting, which is happening in the country outside of India, any other territory outside of India, is not impacted or is not taken care of by the Competition Act. It is only when the players in India impact activities in India or the general public in India suffers, is when the Act can come into play. Also, it ensures freedom of trade by its very objectives. The Act has 3 main facets. It has anti-competitive agreements, which are dealt with in Section 3. abuse of dominant position, which is in section 4, combinations, which are covered in section 5 and 6. I would be majorly dealing with the first two facets, which is anti-competitive agreements and abuse of dominance. Combinations is another beast altogether. It requires a whole different session. But broadly, if I can say so, combinations are basically prior approvals required from the regulator. In this case, the Competition Commission of India, established under the Competition Act, who approve such kind of transactions or these mergers or acquisitions when these are big ticket transactions. What I mean by big ticket transactions are they are big, they impact the market, and there are certain thresholds provided in the Competition Act itself in terms of the turnover of these enterprises who are merging or acquiring, or in terms of their revenue. If they meet the threshold, they are mandatorily required that they should be notified to the commission before they are executed. Those are combinations. Moving on to anti-competitive agreements. There are two types of anti-competitive agreements dealt with under the Act. One being horizontal agreements. The example that I gave you of cartel behavior comes under the definition of horizontal agreements under the Act. The term, horizontal agreement is not mentioned, but the way Section 3.3 defines agreements is agreements between enterprises at the same level of distribution or production. In effect, meaning agreement between competing enterprises or competing companies. On the other hand, there are vertical agreements covered under Section 3, subsection 4. These are agreements between enterprises or undertakings who are operating at different distribution or production levels, meaning one is a seller and the other is the buyer. A typical example being an agreement between a manufacturer and a reseller is a vertical agreement. Mind you, the vertical agreement does not under the Act cover agreements which may be entered into with the end consumer. That is not dealt with because it has a commercial aspect. Therefore, it is not dealing with the end consumer. Those kind of abuses, those kind of practices are usually dealt with under the Consumer Protection Act. Therefore, we can see there are certain overlapping ideas here, there are certain overlapping topics here. But here it is mostly conduct between enterprises, which ultimately affect the end consumers as well. It may affect the enterprises involved, but also the end consumer. Dealing more in detail with the horizontal agreements, I've given you certain examples already. Cement manufacturers coming together and deciding that they will fix prices. Similarly, manufacturers or competing enterprises coming together and deciding that they will limit the production or limit the output of the product that they're dealing with. Competing enterprises or competing companies, when participating in a bidding process, in a tender, they collude and decide that I will quote less, you quote high. I will take this tender this time, next time you quote high, I quote low, and I take the next one. That's also covered under horizontal agreements. Another aspect which is covered under the horizontal agreement is when enterprises decide by way of an agreement that they will control territories. Let's say enterprise A says, I am going to control the region of Amravati. Enterprise B says, I'm going to control the region of Nasik, and similarly Pune, and they say, we are not going to interfere in each other's business. Now, mind you, here, the term agreement under the Act is loosely defined for obvious reasons that these are all illegal agreements. Nobody expects enterprises sitting across the table and signing these agreements. So the term agreement is widely defined under the Act to mean any understanding also. In fact, in international jurisprudence, in EU laws, even a nod in a meeting between competing enterprises have been taken to be meaning as an agreement. Then there are vertical agreements. Vertical agreements, as I defined, is principal to principal relationship. That means the enterprises which are involved operate independently, but there are certain restrictions imposed by one on another because of its market share, probably market power in a certain environment. A typical example would be here. Let's say I am, now this is obviously made up, but let's say I am the only one who supplies water in a particular area. So I am having substantial market power there in that particular area, in that relevant market. and I decide then to operate certain dealers or distributors who are going to distribute this water or this drink or soft drink on my behalf, and I decide a random system, a very, very arbitrary system of choosing my dealers in this particular area by just putting a condition that any dealer whose name begins with R is my dealer, and I will not take any other dealer as my dealer. Now that's arbitrary, that's imposing a condition which is unfair to others who want to be the dealers, who are meeting the criteria, who fit in the bill, but are not granted this opportunity or not provided this opportunity. So those are examples of vertical agreements. Mind you, there is a fine distinction of here how these agreements are dealt with, horizontal and vertical, I mean. Horizontal by their very nature across the world, through their application, through the history of these agreements, are found to be more pernicious, are more harmful to the general public. Therefore, the burden of proof or the standard, legal standard, which is used under the Act for horizontal agreements is a per se violation. I'll explain that a little bit more. If the parties are understood, or if it is proven that the parties have entered into an agreement which is horizontal in nature, meaning that they are operating as competitors but entered into an agreement to fix prices or limit production, it will be presumed that this agreement will have an appreciable adverse effect on competition. But this is a rebuttable presumption. The parties involved, the respondents in this case, will be having the opportunity to show to the Commission, the Competition Commission of India, that our agreement is not causing appreciable adverse effect on competition, in which case the agreement will not be held to be void under Section 3 of the Act. However, when dealing with vertical agreements, the approach adopted under the Act is rule of reason. What does rule of reason mean? Rule of reason means that merely by entering into agreements, which are vertical agreements, I'll give you certain examples of vertical agreements in the coming slides. Merely by entering into vertical agreements or being proved that there is a vertical agreement in existence does not mean that it is anti-competitive agreement. The onus is on the Commission, the Competition Commission of India, to prove not only that there is a vertical agreement in existence, but that such vertical agreement causes an appreciable adverse effect on competition. So the difference here being that in horizontal agreements, the parties involved are provided with the onus or are born with the onus to prove the opposite, or basically to prove in their defense that there is no appreciable adverse effect on competition, or AAEC. But in vertical agreements, it has to be proven by the Commission, the regulator, that there is an AAEC as well. Explaining vertical agreements further, these are the 5 types of agreements, vertical agreements, which are mentioned in the Act itself. However, please keep in mind that the vertical agreements, the way they are defined, it's an inclusive definition, meaning that agreements that are not covered under these 5 subcategories can still be treated as a vertical agreement. The first being tie-in arrangements or tie-in agreements. Now, as it goes, you are tying or bundling 2 products together. There are producers and various examples that we've seen. A very typical example being you buy a toothpaste, you get a toothbrush with it. Now, there is a tying product and there is a tied product. There are 2 distinct products. They necessarily do not have to be sold together. They can be sold individually. That's the whole point. An example of tying agreement cannot be car and tires, because a car without tires does not make sense. It won't run, right? So that is not the purpose. There are 2 independent products which can be sold independently, but are being sold together because that's a condition being imposed by the seller. That if you buy one product, you'll have to buy the other one. If you tie it up to my previous example, what Microsoft was trying to do, Microsoft in this case was also trying to, in its earlier days in 1990s, it posed a condition on the PC manufacturers that if you want our operating system, then you need to necessarily have the Windows Media Player, which was a media player promoted by Microsoft back then, in its system. And you cannot have any other. Although this was not a necessity, there could have been other suppliers of these media players as we have now. But Windows, because of its dominance or because of its market power, in one particular product, which is the operating system, was trying to exert that pressure and tie it another product which was just starting. There are various examples in nowadays also which are being investigated. Apple being a very crucial one. Apple phones are there are allegations against Apple that it uses its so-called market power in its operating system or its iOS or in its Apple Store to force companies, when they are making in-app purchases. Let's say when I do an in-app purchase, I have to go through the iOS model or through the app payment system, which is put in by Apple. And the companies cannot put in their own payment system. So they're tying in. So as we can see, even though the act was meant to be dealing with all traditional concepts, it's still into play when all these new technologies have come into being. Another example of vertical agreement is exclusive dealership, as the name suggests. If a manufacturer or a producer appoints a dealer and says, you will be my exclusive dealer in a particular area, that's a vertical arrangement. Now, because of this vertical or because of these exclusive arrangements, there are certain conditions imposed on these dealers. Like I've given examples, active sales and passive sales. What active sales means is, and which is usually a condition put in by manufacturers to their distributors, that we are demarcating a territory for you. Let's say I appoint I am Maruti car. I appoint a dealer for the state of Maharashtra. And I tell my dealer, I put it in his agreement that, look, you cannot go ahead and go in neighboring states and try to sell your cars there. You cannot make active sales promotions or cannot make efforts to sell your cars there, because I have different dealers who are dealing in those areas. Active sales. Passive sales means that a general buyer coming from a neighboring state comes himself to a dealer in Maharashtra and says, I want to buy a car from you. Usually in competition law, it's seen active sales may be prohibited because it has its own synergies and all advantages as well. Because when I am making efforts and ensuring that there are different dealers appointed in different areas, I need to make sure that they also earn their living. They also have enough, and they cannot be cross-fighting amongst each other. So active sales are still okay to prohibit. You cannot, under law, it's said, prohibit passive sales. If passive sales are prohibited, that means even if a consumer or an end consumer comes to me from a neighboring state and says, I want to buy a car from you, and I have made no effort to entice him to come to me, then also I refuse, that would be wrong. That would be looked at as kind of affecting competition in the market. Refusal to deal, the third category, again, as the name suggests, is simply saying you are restricting your maybe your supplier or maybe the person you're selling to, that I will sell you products only with the condition that if you don't deal with my competitors. Here is also a live example I would like to share. Intel was fined heavily, in fact, billions of dollars. It was fined by the European Union because they found out, or they concluded after their investigation, that Intel was forcing its distributors to keep Intel products only with them. And they were putting a condition that we will only supply you with Intel products if you don't keep our competing product, which is AMD products, with you. AMD chips. This was obviously impacting the business of AMD. And this was not looked at as a competitive behavior or as competing effectively in the market. And therefore, Intel was fined to impose such condition on its dealers. Exclusive supply, very similar to exclusive distribution, is when you restrict the purchase or restricting purchasers from dealing in goods other than those of the seller. It can also be dealt with in the example that I shared before in refusal to deal. When I'm restricting my dealers from taking dealership of other manufacturers. Like usually in India, we see if I'm a Maruti manufacturer, I would not be having another dealership across or in the same premises of Hyundai, because there are conditions imposed that I will supply to you only if you restrict your supply to my product. Resale price maintenance, a little tricky topic here, but in essence, it means it is based on the foundation of principal to principal contracts. So when I sell my product to you, you are free to then price this product as per your wishes. I cannot put a minimum price below which you cannot sell this product. Obviously, as far as maximum prices, we know there is MRP, there are different laws governing it, the Legal Metrology Act. In essence, resale price maintenance means that when I'm selling a product to my to the purchaser, there cannot be a condition imposed which will impose him to put a minimum price on it or the maximum discount that he or she can give. The purchaser is free to put in any minimum price or any maximum discount that they want to. There are factors under the Act. I will not go into detail with these, but there are factors listed under the Act which are taken into account by the Commission when they look into assessment of appreciable adverse effect on competition. The other topic that we are dealing with here under the Act is abuse of dominant position or abuse of dominance. There are three main steps in the way the CCI deals with these abuse of dominant positions or cases. The dominance, as the name suggests, has to be of an enterprise who is exerting this dominance in a particular market. So the first step is defining the relevant market. The Act defines what a relevant market is. And in fact, it's distributed between relevant product market and relevant geographic market. Because there has to be a market, like if you go with Microsoft's dominance in our case, it was in the operating system. So the market was operating system. Intel was the semiconductor chips that it was producing. In cement, it would be the sale of cement in India, so on and so forth. So relevant market is the first step. The second is assessing whether the enterprise who's being alleged to abuse its dominant position is dominant in this market or not. And the third step is whether the enterprise is abusing its dominance. A very important fact to keep in mind is dominance is not wrong under the law. You're not wrong, or you're not on the wrong side of the law if you're dominant. It is only when you abuse your dominant position that you are under foul of the Act. There are various abuses under the Act. Now, these are kind of per se because the way the Act is worded, if I am held to be dominant under the Act, and the moment I am found to be indulging into such kind of conditions, it is held that I'm abusing my dominant position. So if I'm dominant in a particular market and I'm imposing unfair and discriminatory conditions, as just like the examples that I gave you, Microsoft, Intel, like they imposed unfair conditions on the PC manufacturers or on their distributors, they were held to be abusing their dominant position. Denial of market access. This is also an important, where I put, as a dominant player, I put certain restrictions where I refuse to give, let's say I design a product which has spare parts to be given, but I only give spare parts to a few particular people and not to anyone who comes to me. Even the example that I gave you of the distributor, where I decide to make distributors only whose name starts with R. Now that means I am denying market access to all the other distributors who want to come in and participate and increase competition in the market. So that's denial. Excessive pricing, again, as the name suggests, is when I price my product way higher than its cost margins. It was found in a case by the Competition Commission of India that mostly the car manufacturers, when they're selling their own spare parts, their markup is more than 1,000%, 500 to 1,000%, which is a concern and which is held to be abusive. Predatory pricing means kind of opposite to excessive. It means that I'm pricing my product so low that my competitors will not be able to effectively compete with me. Because I have deep pockets, because I'm dominant, I have a deep cash flow, I decide to put my product so low. We've generally see Reliance adopting this strategy, or accused of adopting this strategy, that they price their products so low that the competitors find it really, really hard, which is in the telecom space. Airtel and Vodafone found it really, really hard when Reliance Jio came into the picture to effectively compete with them and increase their market share, and then drive competition out of the market, which is what happened to Vodafone. It's barely surviving now. Leveraging, very similar to predatory, the concept that I was telling you. When you have dominance in one market and you want to leverage that position in another, just like the example that I gave you of Microsoft, when it had dominance in the operating system market and wanted to leverage that position in the media player. In the Shamsher Kataria case that I mentioned, which is the car manufacturers, there also, they try to use their dominance once you purchase their car, that was the CCI's view, to actually sell their spare parts of that particular car to you at a highly excessive price. So as you can see, the abuses also can be interchanged, and there can be the case where I'm abusing more than one conditions under the Act. Lastly, what's mentioned under that is limiting or restricting production. I'm a dominant player. I'm limiting the production. So because obviously economics say that if the supply is restricted, the prices will go up, and I want to sell my product at a higher pace. So I decide to limit my production, knowing that I'm dominant in the market. It is my product which is needed by the general public or by my supply chain further down. So therefore, I limit the production with that purpose. Lastly, the Act has become very important, or it's a marked change from the previous Act that it replaced, which is the MRTP, the Monopolies and Restrictive Trade Practices, because it gave teeth in the form of penalties. Penalties are huge under the Act. There have been penalties to the range of thousands of crores imposed on enterprises in India. Penalties, as you can see, can be imposed on 10% of the average turnover for each contravention for the last preceding 3 years. In cartel cases, as I said, it's looked at for more seriousness. The penalties are even higher. It's 3 times the profit for each year of the agreement, or 10% of the turnover for each year of the cartel. So this is different from last 3 years. There is no cap on cartel. It has to be for each year when the cartel took place. Cease and desist or any other order that the CCI deems fit. With that, I conclude my presentation. Thank you so much for the opportunity. Stop sharing this. Yes, thank you. Thank you so much.
Thank you, sir. It was indeed an enlightening session, and we really enjoyed listening to you. And some of the topics covered were really very, very interesting, and it gave a different insight for us to look at the subject. Thank you so much, Vikram, sir.
Thank you.
Yes. Moving on, I now request co-chairman of the session, Dr. Sahista Inamdar ma'am, officiating principal, Navjeevan College of Law, Nasik. Ma'am, are you here? Can you please switch on your camera so that we can see you? Yes, introducing Sahista ma'am. She's done her BSc LLB from NBT Law College of Pune and LLM from University of Pune in 2008. And she has been a ranker throughout. She has done her NET and SET and certificate course of Forensic Science and Medical Jurisprudence from University of Pune, diploma course in Intellectual Property Rights, in Alternative Dispute Rights in Business Law from Asian School of Cyber Law, as well as Cyber Law from Asian School of Cyber Laws, and certification course in Human Rights from YCMOU, Nasik. She has been awarded PhD in 2016 from Rashtrasanta Tukroji Maharaj, Nagpur University, on the topic status of Muslim women in India. She has been recognized as PhD guide with effect from 26 October 2021. We congratulate you for the same, ma'am. Under Savitribai Phule University, she has been recognized as PhD guide. And her specialization subjects are business law and human rights. She has done numerous refresher and orientation courses and short-term courses. She has presented number of publications, conducted a lot of seminars and conferences and webinars, and she is a resource person with guide lectures for numerous sessions delivered. She has authored 2 books, Constitutional and Judicial Paradigm of Indian Muslim Women, A Move Towards Equality, and Domestic Violence and Gender Justice in India, A Quest for Human Rights Protection. She is also presently working in CSR responsibility activities. I welcome you, ma'am, on behalf of Punjabrao Deshmukh College of Law, and I request you to take over and kindly start your session. Co-chairman
Thank you so much.
Yes, co-chairman of the session. I hand over the mic to Sahista ma'am.
Thank you so much. On behalf of entire team
of Dr. Punjabrao Deshmukh College of Law, Amravati, and Sentinel Solicitors, UK, I extend heartiest congratulations to all the participants who have contributed articles and research papers for 2 days multidisciplinary online international conference on emerging issues and challenges in human rights, commercial law, and women empowerment in contemporary global society. After reviewing all the papers in the capacity of co-chairman of Technical Session 1, I, Dr. Shahista Inamdar, on the commercial law, my concluding remarks are as follows. The topics covered are increasingly relevant today and have thrown up interesting challenges for regulators and will certainly contribute to the growth of knowledge and research in commercial laws. Areas of research and the papers were, which I have explored and found out summarizingly in relation to number 1, data privacy, number 2, intellectual property rights, number 3, cryptocurrencies in India, and number 4, public policy and enforcement of foreign arbitral award in India. So I would begin with the number 1, that is data privacy. Data is an asset of an individual and company. As we can see in today's world, technology is becoming a part of our life. It benefited us to a large extent, but at the same time, it became a threat because with the development of technology, many problems like cyber crimes, data theft, misuse of data have came in front, which has a direct link to our privacy. When such information is leaked or misused by a third party illegally, then it can be treated as breach of privacy. As we all know about Supreme Court has held that privacy as a fundamental right is intrinsic in Article 21 of Constitution of India. But only by holding this view is not sufficient because one should be aware of their rights. They should know various alternative methods, and also if such rights transgressed, one can move to higher authorities for redressal. If they are not aware of their rights, then it will be of no use. So, if, as we all know that earlier only personal privacy was taken into a consideration, but now it is data privacy also which has to be taken into account. Thus, the government should adopt such an efficient mechanism that can alert them to take action as quickly as possible. Besides this, legislatures should enact certain rules and regulations, various laws for collecting the data which are to be secured. The database where the information is stored should be circumscribed with tight security, that even for the experts, it becomes impossible to access it, whereby it can be accessible only by those who have authority to access, and that too for the welfare of the people. Further, only those authorities that collect, process, and store data should be made more responsible. Besides, there must contain a provision of penalty, that is monetary, and also imprisonment, so that nobody should dare to do this, and they should think twice before mishandling the data of individual. This was the conclusion regarding data privacy. Now, let us go towards the second topic. Second topic deals with intellectual property rights. Firstly, I would like to discuss with you all that as technology advances and new interventions came into this world, have made our lives very easier, but it has many disadvantages too. The same is true about intellectual property rights. As new technologies emerge, protecting the intellectual property rights of individuals have become increasingly complex and difficult.
The internet is the biggest challenge it is being facing by our government. New inventions such as photocopying machines, typewriters, computers are a threat to intellectual property rights. Statistics show that most of the IP infringement cases in India involve various other things. Now, let me cover up traditional knowledge. Traditional knowledge is a viable mode of addition, self-food for the cultures and civilization of developing countries. I would like to say that a few legislations have to be followed, like that of Philippines. Indigenous People Rights Act of 1997 need to be incorporated by each and every developing country having abundance of traditional knowledge. Then I would like to come up to cryptocurrencies. If we see cryptocurrencies, very urgent need to implement cryptocurrency and regulation of Official Digital Currency Bill 2021 is of very much in need. And lastly, I would like to discuss about public policy and enforcement of foreign award in India. If we see that every country has their own public policy. Now, I'm talking about international commercial arbitration, and also would like to highlight about New York Convention. If we go through the various judicial guidance and international views over public policy as grounds of refusal of enforcement of foreign awards, it is only expected that public policy will not become a ground to refuse enforcement of foreign award when no other grounds remains in the hands. So this was a summary of various papers which was being given. Last but not least, I am extremely grateful to the organizers, especially Dr. Varsha Deshmukh Madam and her team for their dedicated efforts in making the international conference a grand success. I would also like to congratulate all the participants for thoughtful and insightful contributions. My personal best wishes to all. Also, I wish the deliberations every success and hope the proceedings be published immediately thereafter with the clear mission of contributing to the literature on this ever-growing sphere of corporate and commercial laws. Thank you.
Thank you so much, Inamdar ma'am. It was really a good session by you, and thank you so much for your continued support and for being here and joining us on a very short notice. And we look forward for your continued support and taking programs together with you. Thank you so much, ma'am. I now call upon Dr. D.S. Dote sir, Principal P.D.C.L Briani Science College, Amravati, to say take up his chairman speech. He is the chairman of today's session, and I would like to invite you, sir, to say a few words about the session. But before that, I would like to give an introduction of sir. He is an innovative, creative, responsible, confident, and high achiever with over 33 plus years of teaching experience and possession of high technical, managerial, and leadership skills. He is always ready to accept challenging assignments requiring demonstrative integrity, courage, and innovative problems. Sir has done his doctorate, PhD Physics in 2002. He is MSc Physics passed out in 1988, and he has teaching experience of 33 years and research experience of 19 years and administrative experience also of 10 years. He has more than 46 research publications, and he is presently Principal of P.D.C.L Briani Science College, Amravati, a renowned higher education institution of Vidarbha, Western Vidarbha region. And he was professor and head PG Department of Electronics before being the principal. And he has done many years of research and different programs in his tenure at the college. And he is also third merit at MSc examination, and publication of patents and other achievements also includes appreciation award for mobilization of funds and projects. And his college was awarded Best College for implementation of skills and employment programs. Congratulations, sir, and I welcome you to this international conference. Dote sir, over to you.
Thank you, Anupama. Am I audible?
Yes, sir, you are audible.
At an infancy, I am very grateful to the organizers of this international conference on commercial law, intellectual property right, human rights, etc. I am really thankful to Dr. Varsha Madam to be the part of this conference, as you have inducted me as a chairperson of this technical session 1. So I have listened all these sessions. The first from Miss Elena on cryptocurrency and that is blockchain. So that is a virtual currency. I did not know much about this cryptocurrency or blockchain, but from her speech, I came to know a few things. Now this cryptocurrency or blockchain is going to accept internationally, and in coming days, there will be the very tight regulation on this aspect. And I hope that through this international conference, as it is rightly pointed out by Mrs. Inaugural, that this international conference, where the discussions and deliberations are going on the different commercials law. See, some of the laws are in existence in India. The basic objective or who is the center point of this law is the consumer. So for the consumer protection, there are so many laws: Indian Contract Act, Consumer Protection Law, the Indian Partnership Act, then Arbitration and Conciliation Act. So all the legal persons, legal educators, they know about these laws. But still, there is a need to make amendment and some innovative amendments in these laws which are present. So we hope that through this conference, where the deliberations and discussions are there through some talks or some presentations, some research papers, we can consider this conference as one of the policy lab, that what should be our objective or what should be our responsibility, not to organize only an international conference for the presentation of some papers, but some of the outcomes that will be helpful for amending the law and making the law the useful for the public. So this should be considered as one policy lab, we can say, so that whatever deliberation and discussions are going on in this conference, that should be submitted to the government, so that some good policy should be get evolved in the field of this commercial law. Secondly, the second speaker was Vikram Sopti, and he expressed about this competition law. What first time I come across with this word, and he has very nicely explained about the vertical and horizontal agreements. So I was not knowing till time that what are the different aspects of this vertical and horizontal agreement. So after all the basic objective of all these agreements is to protect the consumer. So nice talk from Mr. Vikram Sopti. And finally, co-chairperson Mrs. Inamdar has narrated and summarized all the papers on the different aspects in this conference. I am really happy that this is really the responsibility of the colleges who are going for the law education, and they should organize many times, frequently, such type of conferences and deliberations, so that it will be helpful to the government for evolving some new policies and some new acts for the consumer protection. Once again, finally, I am very much thankful to the organizer for giving me opportunity. With these words, I remain over here. Thank you. Thank you, ma'am.
Thank you so much, Dote sir. Your kind presence and your valuable words mean a lot to us. And I would now like to invite without taking much of your time, because I am sure everybody has been on the screen since morning. So I now invite Dr. Dabade sir for a quick vote of thanks. Dabade sir. Yes. Over to you, sir. Dr. Dabade. Sir, we cannot hear you. Sir, आपका mic mute पे है.
फोटो करना. Very good afternoon, all of you. I feel honored and privileged to get the opportunity to propose a vote of thanks on this special occasion of International Conference on Commercial Law. I would like to thank all the honorable delegates who bless us with their presence. I, on behalf of organizing committee and the institution, convey deep regards and hearty thanks to our Honorable International Resource Person, Elena Mangasarian, the International Resource Person, International Legal Counsel, Legal Technical Specialist, Columbia University, who graced us with her intellectual kind words and guidance on commercial law on the great occasion of the International Conference. I must mention our deep sense of appreciation for Honorable Elena Mangasarian for sharing with us the best knowledge and guidance in the field of commercial law. We are all inspired by your great words. I again convey heartiest thanks from bottom of my heart to Honorable Elena Mangasarian. I further pay my thanks the second resource person, Indian resource person. I would like to express our sincere thanks on behalf of my institution, the Honorable Vikram Sopti sir, for giving excellent coverage through the speech on the ideas on competition laws. We are all inspired by your great words, sir. Thanks a lot again from bottom of my heart. I further extend my thanks to convener Dr. N.K. Ramteke sir, Professor M. Ingole sir, Dr. Manish Wadive sir, and for their well involvement and cooperation to grant success this international conference. I also extend thanks to all honorable faculty members of our college and non-teaching staff who have cooperated in each and every task to success this international conference. Further, I extend my thanks to Honorable Shahista Inamdar Madam, Official Principal, Navajivan Law College, Nasik. I also extend my heartily thanks again and again for accepting our invitation as a co-chairperson of this international conference on commercial law, as we have paid a valuable task for the purpose of success of this international conference. I heartily thanks ma'am again and again from bottom of my heart. Further, I extend my big vote of thanks to the master of this international conference, Honorable Dr. Varsha N. Deshmukh Madam, the Principal of Dr. P.D.C.L College of Law, Amaravati, for her great leadership, guidance and inspiration and organizing this great function as an international conference to success this great international conference. Thanks again, Honorable Madam, from bottom of my heart. I further extend hearty thanks to Honorable Sajid Sheikh Sir, MD, the Sentinel Solicitors UK and key partner of the organization of this international conference, who have great cooperation, guidance and inspiration to success this grand international conference. Thanks, Honorable Sir, again from bottom of my heart. I extend my thanks to the faculty members of our college and non-teaching staff who have cooperated in each and every task to success this international conference. I extend my heartiest thanks to Honorable Dr. Dhote Sir, who have acquired the chairmanship of this function and guided us very nicely. Thanks a lot, sir, again and again. I extend thanks to technical team, Honorable Preeti Vidhate Madam, Sahil Thakur and Shravan Marodkar for their devoted work to success this international conference. I also extend to all members who have cooperated us in success of this international conference. I extend my thanks to teaching and non-teaching staff again and again for their well cooperation and to great success of this function. I also extend my thanks to all students who have joined this international conference to prove its importance and for their future life. I specially extend my thanks to all respected participants who have joined this international conference from various parts of the country and the globe level, due to which this international conference succeeded in its aim and objectives. Thanks to all again and again from the bottom of my heart. Once again, I extend thanks all of you from bottom of my heart. Thanks a lot. Thank you very much.
I request everybody.
Honorable Anupama Ladha, Madam.
Thank you, sir. Thank you so much,
Thank you, sir.
I request everybody to switch on their cameras so that we can take a group photo.
Madam, there is one announcement. Hello. There is one announcement of technical session. Tomorrow technical session.
Yes, sir.
There is announcement for technical session.
Group photo first.
Okay, okay.
Yes, please switch on your cameras and let us see the beautiful faces. One big round of applause for all the trainers, all the sessions, and everybody who is participating, everybody who has got a chance to speak. Yes, our technical team, can you take a screenshot, please? Of all the screens. Yes, Preeti Madam. Okay, 1 second, I will take it on phone also. Yes, but I think some people have not started their screens. Right.
Okay.
Okay, thank you so much. I hope technical team has taken a screenshot. I too have taken a photograph. Everybody, thank you so much. We will just take 1 more minute. Rampeke sir wants to make some announcements. I request host to mute everybody else, please. Sahil sir, please mute everybody else.
There is announcement for tomorrow technical session. Tomorrow technical session start at 1 p.m. There is 2 technical session. That is one for women empowerment and another is for human rights. After the technical session, the valedictory function to be held. All the participants must be present in the valedictory function. After the end of the conference, the participants submit the feedback form, which is given in the Telegram group, WhatsApp group, and even in the chat box. Therefore, all the students, all the participants, and all the delegates must be present in the valedictory function by way of submitting the feedback form. Okay, thank you.
Thank you, everybody. See you at 1:30 Indian time tomorrow. Thank you.